Okay, good morning, everybody. Now we are live. Please go ahead.
So good afternoon, everyone. Welcome to this lecture on examining national mental health law from the lens of UNCRPD. I'm Sudarshan Kottai. I'm serving as an assistant professor in the Department of Humanities and Social Sciences at IIT Palakkad, and also as the regional coordinator of the Regional Coordinating Institute, Unnat Bharat Abhiyan, North Kerala region, IIT Palakkad. You must have gathered from the notification that this lecture is actually organized in association with the National Coordinating Institute, Unnat Bharat Abhiyan, IIT Delhi. Today's lecture by Professor Amita Dhanda, who is a Professor Emerita at NALSAR University of Law, Hyderabad, will examine the national mental law from the lens of United Nations Convention on Rights of Persons with Disabilities. I'm joined here in person by my students of the first batch of the course titled Mental Health Jurisprudence in India. So those who have joined from other places, please take our warm regards from the sunny and very bright Palakkad with a temperature of around 43 degrees Celsius. We sincerely hope that these lectures would trigger conversations around critical issues and help us to also frame programs in UP at various local places across India with some programs with transformatory potential. So with this, I request Sri Alex Matthew, who is a second year BTech mechanical engineering student, to introduce the speaker and also set the ground rules.
Hi everyone, I'm Alexi Matthew, a second-year BTech student in mechanical engineering enrolled in the course Mental Health Jurisprudence in India. On behalf of Unnat Bharat Abhiyan, Regional Coordinating Institute, North Kerala region, IIT Palakkad, and the class of Mental Health Jurisprudence in India, it is an honor for me to introduce Professor Dhanda to all of you. Professor Amita Dhanda is a Professor Emerita at NALSAR University of Law, Hyderabad, where she also heads the Center for Disability Studies and Center for Legal Philosophy and Justice Education. She started her legal career as a researcher at Indian Institute of Law, Delhi. Justice Bhagavati, the then Chief Justice of India, decided to have her clerk for him based on her capabilities. During her tenure, she did hands-on research on the mental health of prisoners in West Bengal and also suggested amendments to the Persons with Disabilities Act 1995. From 1999, she joined as a full-time professor in NALSAR, Hyderabad. She has written extensively on the legal position of persons with mental health issues. Professor Dhanda was also involved in the negotiations of the UN Ad Hoc Committee that drafted the UN Convention on the Rights of Persons with Disabilities. In 2011, she was a leader of a committee set up by the Ministry of Social Justice and Empowerment of the Government of India for drafting a law on the rights of people with disabilities. Professor Dhanda's research has been referred to by premier institutions, both nationally and internationally, such as WHO, UNICEF, National Human Rights Commission, National Commission for Women, and National Institute of Mental Health. She has written several articles for The Hindu, Frontline, Kafla, and Indian Express, Legal Order and Mental Disorder. Professor Dhanda's book on the legal status of persons with mental illness is a pioneering effort in the field. She is also author of Decolonization of Legal Knowledge and Engineering Law, essays in honor of Ladika Sarkar. Before handing over to Professor Dhanda, I would like to set the ground rules for the lecture. Please note that there are sign language interpreters for the lecture who have joined online, Sri Preeti Sapra and Sri Prachi Gandharwal. I welcome both of you to IIT Palakkad. Those who are online, please note that if the interpreter is not spotlighted along with the speaker on the WebEx platform, pinning the interpreters tab will help to have a seamless experience. You may please send in your questions in the chat box and we will take them after the lecture is over. I request the online audience to keep your mic muted throughout this lecture. Thanks for your patience and cooperation. I warmly welcome all of you once again. Over to you, Professor Dhanda.
Thank you. Thank you so very much. And it's like, once again, one realizes that even if you feel that online learning is sometimes a bit too much, you can connect across different parts of the country and with different people with much more ease than one could do without this technological support. So, and I'm all for, like having this interaction, because it helps you to make connections at several levels. On the topic that I'm sort of speaking to you about today, how do I change the screen? Yeah. So basically what I aim to do with you this morning is to demonstrate to you how the Indian law is in conformity or not with the Convention on the Rights of Persons with Disabilities. Now, the reason why one wants to make this examination is because the convention is an exercise which happened with a very active involvement of people with disabilities themselves. You know, in that slogan of nothing about us without us used to resonate in the UN on a very constant kind of basis. And it was like the United Nations officials, the various state parties were compelled by people with disabilities to start to look at disability rights from their lens and from their perspective, that they couldn't be superimposing whatever they thought was what is required by people with disabilities. In fact, it is the other way around. So because of that, I give the sort of importance to the convention. Now, the way in which I'm going to proceed is I'm going to kind of firstly share with you what the Indian law was before the convention came. One, in colonial times, two, in the after independence. Then I will sort of tell you in essence what the convention is about. And last part of the lecture, I will look at how we have tried to make Indian law harmonize with the convention. Where have we sort of, I would say, slipped up? And at the very conclusion, and I think that's maybe in some ways the most significant learning from this lecture, you are not law people, and you're people in the realm of engineering who are looking at these dimensions of social science. So it's important to be asking, why the blessed hell should you be bothered about what the law of mental health is doing in relation to the CRPD or not? I think that's the concluding part of my lecture, to say why is it of importance to all of us, and I'm emphasizing that, to engage with this issue. I'm kind of going to, the lecture will reach there, but that's the, you could say, the basic objective with which I am doing this lecture with you. Now, to begin with this whole question of colonial laws and what they did, you would find, I mean, we had a Lunacy Act of 1912, and it used to define a lunatic as an idiot or a person of unsound mind. So if you were, and I'm sort of using the language of the law at that time, not something that I endorse as language. If you want to sort of translate it into current day language, you would say they were including mental illness and intellectual disability in one definition. What was the primary concern of the law? They were only concerned with the fact of that people who could be like dangerous and unfit to be at large, who could be dangerous to society or themselves, they should be housed in asylums, and they would be compulsorily picked up and put in there. The whole question of that, if you thought of the entire business of asylums was to address the law and order problem which came in from people living with mental illness or persons of unsound mind. But you did not see this as treatment. You saw it primarily as detention. And it's interesting just to share with you that if you wanted to voluntarily get into the asylum and seek treatment, it was not the rule, it was the exception. It was like you had to ask for permission. If they thought that they could do some good to you, they might agree to do so. And of course, if you came in as a voluntary boarder, the moment you asked to be discharged in 24 hours, you had to be let out. But it was primarily the picture was of that, okay, you have these people who are dangerous, shouldn't be allowed to roam around, and there should be a process by which they can be coming in. So you had the Lunacy Act of 12, which we had as the law till as late as 1987. In fact, even later than that, because the enforcement of the law took even longer than. But before that, there were a range of lunacy laws, but this is all I want you to appreciate at this point. The other thing which also happened at the same time was the Lunacy Act was about care and treatment in mental hospitals. Other than that, you had laws which kind of, you could say, controlled the kind of contracts you could enter into, or let's say the civil status of people with who had any kind of a mental illness problems. So they could not enter into a contract, and they were, especially if they entered into one, the contract would be declared void because they were doing it in a state of unsound mind. Could not inherit property till 1928. That means didn't have a status, any kind of a civil status. Then subsequently, they were allowed to inherit, but could never manage their own properties. There was an elaborate system of who could manage their property, how that person is to be appointed. So you had a manager for the property and you had a guardian for the person with mental illness themselves. That was the way in which the law operated. You also had some provision for that if an offense was committed or a crime was committed by a person of unsound mind, then if the person did not know the nature of the act, that it was wrong or contrary to law, that person was not culpable in law. That means you could not be prosecuting that individual. Now, what is I'm doing this throughout, so what was a kind of picture of the person with mental illness? You could say that they were primarily seen as dangerous and incompetent. The law did not think of them as any other way. And this view pervaded across laws. It was like in the care and treatment laws, in the laws relating to civil status, in the laws relating to criminal culpability. It was a heavy imprint on the legal mind space. It's an important thing for you to take note of, because it significantly influences the manner in which, even as philosophies and ideologies change, this particular way of looking at a person with mental illness has kind of, you could say, become a very integral part of the legal DNA. I want you to keep that particular thought in mind as I proceed further. After independence, like I said to you, like the 1912 Act continued on the statute book till as late as 1987. There were like various efforts at trying to change the law, primarily saying that no, it's not correct to be thinking of mental illness as a law and order question. It's a health issue. It is like you should be making treatment accessible to people with mental illness. You shouldn't be having these courts and magistrates controlling the process. Doctors should be much more in the driving seat. The sort of, what should I say, civil death that you are attributing to the individual should be questioned. We should have much more opportunity for doing voluntary sort of stuff. So this was the background. What did they land up doing? They came up with a new law, which they called the Mental Health Act of 1987. And importantly, you were no longer only confining people in hospitals because they were dangerous to self or others, but you were also sort of talking in terms of care and treatment as a reason for persons getting admitted into hospitals. The other thing also started to happen was in the Lunacy Act, the entire power of entry and exit was with magistrates. It was a very much illegal jurisdiction matter. But with the Mental Health Act, at least for limited period of time, even when you're compulsorily committing people in, compulsory means that it's not by my choice. I am not going there and filing an application and saying, I want admission in this hospital. You are saying you need to be in this hospital. So that was that's a basic difference between seeking a voluntary admission and seeking a compulsory admission. And so you started some of that power especially when you were admitting for short periods of time, was also given to doctors. That was the other big change which came in with the Mental Health Act. But this change primarily only came in the care and treatment law. I spoke to you about that the law had this entire regime on the civil status of people with mental illness. So be it your, the freedom to contract, your to be able to manage your property, to get married, to stay married, to vote, to stand for elections, to hold office. In all of these other places, the fact of unsoundness of mind could be a basis for these rights being denied to an individual. So this is one particular part of the law, what I have here. Another development which happened subsequent to the 87 Act was the enactment of the first Persons with Disabilities Act in 1995. Now, it had about 7 odd conditions which they included in how they defined disability. So you had blindness, and you had hearing impairment, and you had low vision, and you had leprosy cured, and you also had mental illness. Now, this factor of mental illness coming into a law, which as such was addressing the social economic rights of people with disabilities, was about providing a certain kind of welfare to people with disabilities, could be considered significant in relation to how the law was perceiving people with disabilities, people with mental illness. You were not only thinking in terms of how you're going to take away their freedom and liberty from them or compulsorily treat them, but you were also saying, okay, some kind of welfare provision should be made for them. And that's the significance of this inclusion. The criminal law did not change. That same point that you don't know the nature of act, and you don't know it's that it's wrong or contrary to law when you did it by reason of unsoundness of mind, you could still be held not culpable. Now, how you could say what changed? Because I am doing this one, with every change in the state of the law, I'm also sort of putting out this one screen which is saying, all right, what are the kind of changes which came with this particular change in the law? One is though the attribution of dangerousness remained, that did not go away. The condition was still also viewed as treatable and not just a law and order. So you could say that, into that way in which you envisioned or pictured mental illness, you only didn't see them as dangerous, but you also saw the condition as something which can be alleviated with treatment. So they also introduced the whole question of voluntary treatment. Remember when I was talking about the Lunacy Act, I said they allowed you to apply, but whether you will be given admission or not was totally left at the discretion of the authorities. It was an exception, not the rule. The rule was that people will be compulsorily put in. In the Mental Health Act, they tried to change that and recognize that a person could say, I need treatment, and ask for it. And that provision in relation to that, if I don't want to continue the treatment, you have to discharge me in 24 hours. That's where the change came. They recognize that the person can seek treatment, but they did not recognize that the person had total authority of stopping that treatment, something which they did in the Lunacy Act of 1912. You find here that if the doctor or if other, like a concerned medical team thought that no, this person is asking to stop treatment, but in fact he needs treatment, you can continue that person, after sort of setting up another new medical board and look into the whole matter. I'm only pointing this out to sort of say to you that, you recognize competence, but you recognize competence when it is exercised in a manner which the authorities thought you should be using it for. So if you say, I am not well and I need treatment, that seems to show judgment. But if supposing you don't like the treatment you have got there and you want to stop it, then the law says you lack insight. Your mental illness has so colored you that you don't realize that you need treatment. I'm only pointing this out to see that the leaning of the law is towards the professional, not towards a person with mental illness. So, it becomes like that when I say I want treatment, I have competence. When I say I don't want it, I'm still incompetent. It's significant at several levels. So I'm just kind of, again, flagging this issue. I told you about the inclusion of mental illness in the disability law. Now, what one has to sort of take on board there is that they were primarily only focusing on the chronically mentally ill, people who had been ill for years together, people who were hugely dysfunctional. So you were not talking about mental illness as a disability, which I am managing along with doing other things. You know, it's like I'm asking for some level of reasonable accommodation, maybe saying that, you know, like, give me, I can turn and come up to work at a later hour. I can get different kinds of, you know, timeouts. I can have a quiet place I require. That kind of vision of disability, of seeing mental illness as disability, was not there. It was just that somebody who has been ill for so long that they have become totally dysfunctional. That was the kind of person with mental illness that they brought into the Persons with Disabilities Act. Some little small changes in the criminal law came in, wherein you started to also recognize that if a person is being tried for an offense, then that person needs to be checked out and, you know, treatment offered before you start a trial, as far as we support them. So this notion of the therapeutic, this notion of that mental illness is a treatable condition, started to get into the law. This is where we are. And then we come to the UN Convention. See, I wanted to sort of very quickly point out to you that you had this very typical kind of a way of looking at people with mental illness as incompetent, dangerous people who had to be literally locked up, and who would be locked up depending upon how the authorities saw the entire question. The person themselves, if they thought they required medical treatment, then in the Lunacy Act, it was totally at discretion of the authorities. In the subsequent act, your wanting to get out was totally left to the judgment of the doctors. So what is it that the UN Convention did? What is a radical change it brought out? Why am I kind of trying to put in some attention to this and saying, at least the vision of the convention should inform all of us? So one, they included psychosocial disability or mental illness in the definition of persons with disabilities. They did not say this is an illness and not a disability. They very much accepted that it was a disability. The second thing that because they said it's like some of it may come from the way in which your mind is wired. The other part of the disability may come from how the world looks at people who are neurodiverse, who think differently, whose mood swings and all of that are of different order. They also brought in the whole notion of equality and non-discrimination and said that, you know, this has to be extended to all persons with disabilities, which included persons with psychosocial disability. I've already told you about the range of civil status denials which are imposed upon people with mental illness. You know, this whole question of not being able to contract, not marry, not stay in employment, not manage your own property, not vote, not stand for election, all that whole lot was evidently something which the law was doing, saying that if you are a person of unsound mind, you are incompetent. So the convention, the big thing it did was that one, it recognized psychosocial disability as a disability. Next, it said that, and this particular provision of the convention has been amongst the most controversial ones. I mean, if we have some Q&A and some curiosity on your part, I can sort of expand further. What basically the convention did was, it recognized that all persons with disabilities, which is including persons with psychosocial disability, have legal capacity in all areas of life on an equal basis with others. So this distinction that has been there for time, I don't know, for an innumerable time immemorial, almost one can say, about saying that if you are a person of unsound mind, you don't have capacity to be able to make decisions for yourself. That got very foundationally challenged by the convention. They said you are not only a person before the law, you were also had the freedom to act according to what you thought was good for you. You could take support. You had the right to seek support, but it was not like that you were compelled to seek support. States were required to make arrangements for support, and a person could take it or not take it. The other important part of the convention is, I have told you that in fact, the two major laws I've discussed with you in relation to India, both of them were about compulsory care. So all the states over there, because I mean, in my intro, you were told that it was a very integral part of that whole negotiation on the convention. So you had state parties wanting very strongly that this compulsory care provisions should be upheld and endorsed by the convention. The convention doesn't do that. It's totally quiet on it. It doesn't also say that it prohibits it, but it also does not permit it. What it does do is it recognizes that all persons with disabilities have physical and mental integrity on an equal basis with others. They have a right to live independently and in the community. So if you see, just to see this combination, they have not endorsed it, and they have recognized the positive rights that you have physical and mental integrity, which necessarily means nobody can touch you without your permission, and that you live in the community on an independent, live independently and in the community on an equal basis with others. Both of these seem to make compulsory institutionalization a big question mark, and one could even be saying that it doesn't permit it to be used. What is it that in terms of change of perspective, I would want to stress on in relation to the convention? It's like suddenly you're finding that it's including psychosocial disability or it's including mental illness because it is seeing it as a part of human diversity. So if persons with disabilities have a right to life on an equal basis with others, that also includes persons with psychosocial disabilities. There is a proactive commitment to lift both physical and mental barriers. Now, see, physical barriers is not something which is of such great relevance for people with mental illness. Mental barriers, to the extent of the kind of stigma that you have, the sort of, prejudice that you may have, that's a very integral part of exclusion of persons with psychosocial disability largely happens from there. Also, the entire range of normative barriers, that is the barriers which the law has placed on. So unless and until you decide to lower those barriers, you really cannot have the sort of inclusion that you are wanting for people with disabilities, including people with mental illness or psychosocial disabilities. The other thing is, I told you that when they brought in mental illness in our disability law, the disability law was largely a welfare statute. Our courts and all that try to lift it up to look it more like a right, but largely a welfare statute, which means you give somebody what you think, quote unquote, is good for them. And the fact that they only thought of including the chronic mentally ill, you were not really sort of, making them subjects of rights. You were primarily continuing with the whole welfare option in our law, that is the disability law of 95. What the convention did was it shifted gears and it started to speak about providing for people with disabilities to have the same kinds of rights as are granted to the non-disabled community, to say that they must have a big say in how they want to organize their life, what kind of benefits should be put in place for them, right? And that's why I said it in the beginning also, the slogan, nothing about us without us, is a very critical part of how this convention was made. And because of this large-scale participation of people with disabilities in that enterprise, that one sees this convention a little differently from other human rights conventions. And also in the way in which the treaty body, which is monitoring this convention, there's a large presence of people with disabilities. There's an obligation that the convention itself has placed on that, persons with disabilities should have, they must be very integrally involved in any kind of law or policy which is made for them. It's a right in the convention. So the right to participation, the right to be consulted has been included in the convention as a right in itself. So there is, I mean, it's because of these kinds of principles which have got incorporated in the convention that I feel we have both signed the convention, we have ratified it. So we've made a commitment that we will bring our own national law in conformity with international law. And national law, what I said to you about the Lunacy Act and the Mental Health Act, had a certain way of looking at persons with psychosocial disabilities or mental illness. The convention was asking for a shift. So if we really feel that that's the way in which they should be, then, and we have made an international commitment, it's important to be asking, okay, what did we do? We brought in two major statutes. One was the Persons with Disabilities Act of 2016 and the Mental Health Care and Treatment Act of 2017. These were two major statutes which were brought in to say we are making our national law come in harmony with what the international law is. Now, necessarily then the question, I said right in the beginning that no, they did not do that. So they claimed to do it, and they kind of assert that the preamble of both the statutes say that this law is being brought in to bring it in harmony with the convention. But when you start unpacking the convention, the laws, you find that it's not really done so. What they have done is both these statutes, like the 2016 Act, that is the Disabilities Act, recognizes legal capacity, but it also speaks about limited guardianship and absolute guardianship, and says in the first instance, you start with limited, and then you can make it full guardianship and all that stuff. I mean, we were part of the whole first draft came from the Center for Disability Studies at NALSAR. We had brought in the notion of limited guardianship for very different reasons, just as a transitory thing. But when it got enacted by the state, it's become a permanent thing that, you can be firstly given a limited guardian, but if that doesn't suffice and you need more help, then you get full guardianship. Now, the convention has dropped guardianship, has said, no, you have to be looking at, the person has to have the freedom to look at, organize their own affairs as they see fit. They can seek support, but the distinction between support and substitution was very important in the discussion on the convention. So they did not, but we have gone ahead and brought in a guardian. In the 2017, the 2016 Act at least makes a statement on legal capacity being possessed by all. And 2017 has a very, very complicated kind of what kind of person is considered to have legal capacity. And then made a very elaborate system of substitution. So you allow for advanced directives to be made to say that when I am not well, so-and-so will take my decisions, or so-and-so will be my power of attorney, or my nominated representative who will make decisions for me. Now, I have been given the freedom to nominate a representative, but if I don't nominate someone, the statute has created a list of people who automatically become my nominated representative, including a person who is a paid support person. So that's the kind of regime we have created there. See, I'm doing the big picture kind of lecture for you because I think that's what is important for non-law people to know about the law. I mean, to know that this is at core what we are doing. What are the other kind of provisions in these in the 2017 Act? Because see, the one difference between the 2016 and 17 Act is in the 2016 Act, persons with mental illness or people disabled by mental illness is one of the categories of disabled people. Otherwise, it's covering 21 other categories. In the Mental Health Act, on the other hand, the Mental Health Care and Treatment Act, you're only talking about people with mental illness. So to that extent, this becomes a more special, made exclusively for them kind of statutes. So what is it that this statute is doing in addition to what I've already narrated to you? It says that mental illness should be treated the same as physical illness. without recognizing the fact that you haven't really recognized the capacity of the person with mental illness like you recognize for physical illness. So if I'm a physically ill person and I may be diagnosed with cancer, but I decide I don't want treatment, you can't physically take me and force me to take that treatment if I don't want it. So if an ambulance comes, if your heart treatment is required, any one of those things, it is coming primarily from the fact that you are conceding to my own judgment and you won't touch me unless I consent to it. If you do, it is battery, it is like assault. They've also brought in, which is an important thing, they brought in non-discrimination in insurance. Earlier, people with mental illness could not get medical insurance. You've got a change in the law by which you're permitted to do it. You've also said that psychotropic medication should be available in all primary health centers, and if it's not, or if it's a list of prescribed medication and it's not available, then you can buy it on your own and you can get a reimbursement from the state. They have continued with compulsory treatment, only the safeguards have been made much greater than they were there in the Act of 1987. You could say, if one has to look at in terms of the mix, you can say that the 2017 Act, much more emphasis has been given on the therapeutic or the treatment part of mental illness, but dangerousness has not been abandoned. It's not like they're saying that people with mental illness are not dangerous. That still continues. They have only kind of made the bigger focus of the law on the fact that this is a set of people who require treatment, and this could be the way in which that treatment can be provided. They're also saying that just because you're taking treatment, your civil status laws, your civil status should not be affected. It should not be evidence of the fact that you lack civil status. But no change has come in the civil status laws. You've also made some kind of provision to say that if you are taking treatment, or if you attempt suicide as a part because you're not mentally well, you shouldn't be prosecuted under the penal law. So that's the kind of, and this is a provision which even the new criminal law that we have got has continued. So this is what they have done with the 17 Act. Now, because I've been doing this kind of evaluation of every development, how would I sort of evaluate this particular law that has come in the 17 Act? I would say that, okay, it's got some human rights varnish, but at very core level, it is still standing on the two pillars of dangerousness and incompetence. It's come up with such an elaborate system of substitution. And if you have such an elaborate system of substitution, you're actually insisting on the fact of that the people with mental illness at significant times could not be competent to take decisions for themselves. And this could be an alternative measure that they took. You are also sort of saying, you're saying, oh, at least have autonomy because you're allowing me to make that advance directive. You're allowing me to nominate that representative. So that is, to that extent, my autonomy has been recognized. But I don't have to, sort of like go through this, the various minutiae of how this has been done. But primarily at core level, I'll make two statements. It's like, yes, you have the authority to give an advance directive. But that advance directive, whether it be followed or not, under what kind of conditions, all of that is totally left to the discretion of the doctors before whom that advance directive comes. So it's like literally by giving with one hand and taking it back from the other, by the other. And I would make this last other statement is that that's why I did that entire business of the colonial law and what happened after independence. There's been a long history of presumptions and accompanying, notions of attitudes of prejudices of incompetence against people with mental illness. This has still prevailed in the 2017 Act. The human rights perspective is only advocated, and some level of hat tipping has been done, but it has not very critically altered the way in which this particular condition is viewed by the law. To my last slide, and what I said, in some ways, I would think that why this should be a concern, why this entire interaction between the mental health law and the Human Rights Convention should be of concern to you. See, it's like what is important for us to appreciate is that mental illness, you could say, is a part of a continuum. it kind of, you could have distress, you could have disorder, you could have severe illness, you could have, it's an entire thing. And we could be going up and down on that continuum. It's not really a binary of wellness and illness. We are, all of the various sort of surveys and reports are telling us that the levels of stress and depression and mental disorder is becoming, very much, okay, it's like it's kind of quite pervasive and high degree. And it's like the person with mental illness is not some alien persona, but it's actually somebody who all of us also meet with. It's like I may have an episode, I may have something which has not gone too right for me, I may need help at that point of time, I may pass over, I may forget. Long time ago, this guy, Irving Goffman, had done a study on stigma. And he was making this big distinction between people who were discredited and people who were discreditable. Now, the distinction between the discredited and discreditable is basically just this, that you are discredited when the whole world comes to know that you are having these mental illness issues or you're having these distress issues and you've not been able to handle your behavior and maybe you had to be locked up or some other compulsion had to be imposed on you. So everybody knows about you, your reality is out in the open. Discreditable, on the other hand, is the sort of battles each of us fights in the privacies of our bedrooms and our other, whatever sort of refuges we have created for ourselves. We go through them, but this is not public knowledge. We don't have a language for talking about, this everyday distress in a manner like, say, you can talk about your blood pressure, you can talk about your sugar levels. At the same time, you need the same sort of accommodations. On the days on which you're not doing too well, you maybe want that quiet. You want that you should be able to miss a class without losing attendance. All of those factors make a difference. Say for mental health to get its full due, it is important that you can make disclosure and talk about this as a part of human suffering. It's like we suffer on so many counts. This is also one of these very integral parts of the human condition. And the fact that I make that disclosure, if it's going to mean loss of autonomy, respect, and dignity, and anybody at all can tell me how I should live my life, then it's difficult to go ahead and do that disclosure. What I've shared with you is that the manner in which we have made that law, the earlier law as well as the more recent law, we have made disclosure difficult. And if disclosure is difficult, that means if I ever get this distress, I would have to battle with it alone. And it's not the right way to go about it. So I feel as all of us as people who are part of the whole, you could say the human compact, need to see this issue in a more inclusive and universal manner. Thank you so much. So I have kind of just kept that 10, 12 minutes for your questions.
Yeah, thank you so much, Professor Dhanda, for keeping the time. So we have around 5 minutes because the break is at 12:55. They have a 1 hour break for lunch, so it's better not to disrupt their schedule. So if you have any questions, you can ask. You feel free to ask any questions.
I would sort of encourage you to ask, basically for this reason that, for a speaker, when you come to a new audience, your only measure of whether you made any connect at all is in the one or the two questions that you may ask. And I would sort of, unlike your professor, I would say that if you have those questions, you give me those 3-4 minutes also and go a little late for lunch.
Even you can write it in a paper and give it to me. I can even ask if you don't want to ask there. You can write in a paper and forward it to me also. I can ask on your behalf if possible. Otherwise, you can come here and ask from there also. You can ask. So maybe you can take some time, maybe, as Professor Dhanda mentioned. So maybe in the meantime, I will ask.
Yeah, go ahead,
Because
Sudarshan. Yeah.
whenever I actually discuss this with students and other mental health professionals, the response would be like, with respect to insight, like sometimes how do we navigate between care and violence? Because some patients would require that kind of a force, and mental illness is not like any other illness. So this kind of an argument and counter argument mostly surfaces. So it is, and also I find that UNCRPD itself is not something which is well known to mental health professionals in India, because even when I was doing my MPhil medical psychology dissertation, there was like the mental illness was mentioned. It was only the professor of psychiatric social work who actually mentioned that you should change this phrase into psychosocial disorder. She only introduced us to actually even CRPD. So why is there a hesitation, or why is there a silence around UNCRPD even among the mental health systems and mental health professionals is something that I would like to ask.
I didn't fully get you, Sudarshan, but I am presuming that you are raising issues around the whole question of that a total ouster of force is really not possible. That's the point you're making. And so we must concede to that use of force in the law. That's the point you're making. I got it right. Now, the counter question I would ask is that are emergencies unique to mental illness? They are not. And in physical illness also, in states of emergency, we do act for other people, and we subsequently kind of get validation for what we've done. We don't have it in the law. The law requires that you have to obtain the person's consent, and you can't act on that individual without the consent. That's the default position of the law. But if supposing somebody just, like, you're standing here and a student of yours was to just fall and, like, go unconscious, you're not going to wait for the person to come into consciousness before you do any kind of, intervention for them. It's like only for people with mental illness that you want an express provision in the law. And I think it's a distinction that has to be appreciated. Nobody is saying don't make the humanitarian interventions. Nobody is saying that the human interventions shouldn't be happening. But to ask for a carte blanche from the law is a very different thing altogether, because then the exception becomes the rule. You don't try to consult with the individual. You just decide, oh, this is a person with mental illness, requires help, and I must intervene, and then don't come back to the individual at all. You also have centuries worth of exclusion of the right. Now, if you recognize that force again in the law, there is going to be no change. Even now, we are struggling with any kind of change to come. But if you don't have that permission from the law, it means your whatever force you exercise, it'll be no more than what you exercise for a person with physical illness and how far it will go. If you, on the other hand, if the law permits you to do it, then what you see as emergency and what I see as emergency, like we have, I'm quite certain, of course, you are teaching young adults, but all of us have encountered this thing of when every parent thinks that their particular child is very vulnerable and very buddhu and doesn't know anything at all and needs to be, so the kind of umbrella of protection they want to put is disproportionate to what is required. And if the law permits you to use that force, then the chances of all these aberrations getting to be normalized is that much the greater. There's a distinction in the two things. Nobody is saying that you don't make the human intervention, but why do you need the permission of the law to make that human intervention when you don't need it for other kind of medical crises?
Thank you so much, Professor Dhanda. So if you have any questions, please do ask. No questions. You can come here.
I can't see them also, so I can't even.
Oh, you can ask for the information. Okay. So he's asking his Purusharth Singh, you are second year student, BTech. So he's asking how far the mental health services are accessible and affordable to different sections of the society, right?
But see, the thing is that a large part of, if you look at the formal system, I would say possibly they're not even accessed very easily by people, because somehow or the other they find local therapeutic interventions to be more powerful. So you will find the faith healer, the local, your local priest. I mean, it doesn't matter. It may be the temple priest or the church priest or whichever, they kind of seem to have way more significance and importance to people to address distress in the first instance. The number of psychiatrists we have in the country is abysmal. I mean, it's like if that was the only medium through which we were providing mental health care, we can't afford it because we don't have enough number. And whereas actually speaking, medical intervention is only one part, but you can, whether it comes to peer-to-peer support, whether it comes to family counseling, whether it comes to art therapy, there are so many other ways of looking at mental health care. You don't have to limit yourself to just psychiatric services. But that requires us, that's the reason why I ended with that fact of that you need to recognize the fact of mental illness being very much a part of the human condition. That all of us go through these up-down phases. Most of the time we come out of them and we carry on and we don't make heavy weather of it. Sometimes some people stumble and can't move forward. And the way in which we then address the issue makes it even more difficult for the next person to promptly ask help. That's my biggest quarrel with the law, that it actually prevents people from asking for help rather than help people to get help.
Is there any other questions? Anyone? Okay, so maybe finally I would like to ask you, like, what is the status of UNCRPD implementation in various states? Like, how do you have anything to say about it? Like, because even though we have enacted these two acts, 2016, 2017. So how does this affect the everyday life of mental health systems? Because I feel that it is still very, very biomedical in nature, and we don't find any such conversations in the mainstream mental health systems in the country. Did I reach across? Did you get my question?
No, I did not get your question. If you were asking me.
Okay, I was asking you. I was asking what is the status of the UNCRPD implementation with regard to how the mental health systems have achieved the kind of programs and philosophies which are part of UNCRPD. So we see mostly a biomedical nature of treatment interventions in most of the mental health systems.
I think your mic is really bad, Sudarshan. I can hardly hear what you're saying.
Mic say maybe here. So am I audible now?
Yeah, this is better.
Oh,
yeah.
Okay. So I was asking, like, what is your impression about the implementation of UNCRPD in India? Because I see, as far as I understand, most of the mainstream mental health systems are still very biomedical in nature, and as you mentioned, art therapy and many other interventions, and the kind of philosophy which is put forward by UNCRPD is not
Yeah, but that is exactly why, Sudarshan, I said that if you look at the act, the law which they have made, as well as the policy which they have made, they have gone for the biomedical option. They have really not gone for the mental health option. So the reason why, whereas the UNCRPD is asking us to go for a mental health option and not for the biomedical option as an exclusive option. What we have done is that we have gone for an exclusive biomedical option. So if we don't critique it and we don't say that this cannot be seen as satisfying the UNCRPD, we are validating something which I don't think requires to be validated. The treaty body also, the treaty body has very strongly, it has not endorsed either of the legislations as doing what the CRPD is requiring the government to do. But the government is claiming that what they have done is what the CRPD requires.
Thank you so much for your valued time, and you have taken your valuable time in the midst of a very busy schedule, I know, and you could not come over to Palakkad, and I think it is better as of now because it's very hot here. It's simmering heat. So I definitely look forward to hosting you sometime in person here.
I would like to come. I would definitely like to, and I would then have a greater chance of having your students talk.
I would like to invite Sri Akhila Jos, who is an MSc Physics student, to propose the vote, please.
Good afternoon to one and all present with us online and offline. I am Akhila Jos, a second year MSc student enrolled in the course Mental Health Jurisprudence in India. At the outset, on behalf of Unnat Bharat Abhiyan Regional Coordinating Institute, North Kerala Region, IIT Palakkad, and the class of Mental Health Jurisprudence in India, I would like to express our sincere gratitude to Professor Amita Dhanda for accepting the invitation in the midst of a very busy schedule. I gather from Sudarshan sir that several back and forth communication have made this possible from 12 p.m. to 1 p.m., which is our class hour. This is so kind of you. It was indeed a great learning experience to listen to you, whose views and perspectives are shaped by many decades of experience and expertise in the field of law and mental health. Scholar Preeti Sabra and Scholar Pinke Khandelwal, sign language interpreters, who helped us immensely to make this lecture inclusive and barrier-free. Thank you so much for being with us today. I thank all the participants and my classmates for being part of this lecture and for their active participation. I extend my sincere gratitude to Unnat Bharat Abhiyan National Coordinating Institute, IIT Delhi, for all efforts in streamlining this program. I gather that Scholar Prerna Sagar from NCA IIT Delhi have been ultra prompt in coordinating this event from National Capital. Scholar Sana from Media Committee, IIT Palakkad, has helped us in publicizing this event. Thank you very much. We remember with utmost gratitude the IIT Palakkad IT support team, who has worked diligently behind the scenes in materializing this event. In this regard, the service of Scholar Soju Francis and Scholar Subodh have been significant. I thank all of you. I take this opportunity to thank our Sudarshan sir, who took effort to arrange this lecture. And once again, I thank all of you for making this lecture successful. Thank you.
Okay.
Thank you. Bye.
All right, Sudarshan, bye.
Thank you. Bye. Bye.
Bye.